Did you know that California has mandatory sex offender registration laws so that if you or your loved one has been charged or convicted of a sexual offense, you may be required to register as a sex offender, possibly for the rest of your life? My name is William Pernik. I'm a criminal defense attorney and a founder of the Pernik law firm. And I'm joined today by one of our attorneys, Mr. Arcolano, who does a lot of the work with our clients who are charged or convicted of sex offenses, helping them with specifically the registration issue. In this video today, Mr. Arcolano and I are going to discuss a number of important topics that pertain to the area of Section 290 sex offender registration. We're going to talk about who is required to register as a sex offender. What does registration actually mean? What could be the significant, profound consequences that we see with so many of our clients who have been court-ordered to register, and how that sometimes can be used to abuse or harass a person? And finally, Mr. Arcolano is going to share with our audience the important process that has recently been made available to many people who have previously been convicted of sexual offenses in order to help them get off California sex offender registry, or at the very least educate them about the steps they can take in the future to clear this stigma, to clear this stain, to remove this very onerous obligation from their criminal record. Dustin, I know that the topic of sex offender registration and sex offender registry removal is not a popular one in our profession, but nonetheless, there is a profound need out there for lawyers who know how to help people remove that from their record. Is that true in your experience?
Definitely. I recall we got into this because we got a referral from one of the treatment providers we've worked with a lot in the past, who recommended this gentleman approach us and ask what could be done so that he can experience some relief from the anxiety that having to register for an offense that happened a significant number of years ago.
Decades, if I remember correctly, right?
Yes.
For that particular client.
I believe it was 20 or 30 years ago.
Correct.
He was experiencing significant anxiety about this, shame, humiliation. Every time he applied for a job, every time he applied for housing, this was something that would follow him and crop up for him. And he was very aware the fact that his name, his address, his offense was branded on the internet for anybody to just access and find. It was a great source of shame for him. So he comes to our office, he wondered what could be done, and the law was actually just changing at that time. Until that point in time, we would have had to turn him away and explain, I'm sorry, but there are life consequences for having to register as a sex offender. Unless you can get a certificate of rehabilitation, which is a very onerous process.
Or a pardon.
Right, there is no relief for you. Fortunately, in January 2021, the California legislature enacted Penal Code Section 290.05, which allows for us to petition for the termination of one's duty to register once a satisfactory period of time has passed.
And so, with respect to this section, Dustin, one of the really remarkable changes that I think you've touched on just a few moments ago is that prior to this law having been passed, sex offender registration was not only mandatory, but it was for life. What that meant was that even if you committed a very minor offense, you could have committed a misdemeanor offense of annoying a minor, for example, of being convicted sometimes under sketchy circumstances of perhaps indecent exposure. We have a lot of these cases where persons are drunk, they are, arguably urinating in a public place, somebody is hypersensitive, hypervigilant, they think that the person is masturbating, maybe person didn't have good legal representation, they get charged and convicted of an indecent exposure. Now they have to register. And for most of my career, these folks would be looking at lifelong registration. And that was catastrophic to them relative to the fairly minor nature of the offense. They didn't kill anybody. They didn't hurt anybody. They may have conducted themselves inappropriately, but for the rest of their life, their information would be out there and they would be discriminated against in employment and housing. They could be harassed by neighbors. Their property could be vandalized. The stigma of it, people have driven themselves to significant mental distress as a result of it, and until 2021, there was just no legal mechanism to change it.
Right. Just hearing that you are a sex offender creates a stigma all into itself. People's brain immediately jump to the worst case scenarios.
Exactly.
That you raped somebody, that you molested a minor, things like that.
And what this new law does that I think is really significant is is that for the first time in our history, since we started implementing this registration laws, it actually creates different tiers. And this is really significant in a legal sense because we're no longer lumping every person who has to register into one group, so that a person who had an indecent exposure incident, in a park is not lumped together with a serial child molester who had multiple young victims and engaged in, really inappropriate, horrible conduct with them, so that we don't have a person who perhaps had sex with an underage person and had a judge use or perhaps misuse their discretionary powers to impose registration on that individual. They're just not treated the same. And I think that's really significant, in my opinion.
It is a significant development, definitely. There are still offenses under this new law that still have lifetime registration requirements, but many of the charges enumerated under 290 have been reclassified as either Tier 1 or Tier 2. Tier 3 still has a lifetime requirement. Tier 1, however, you're eligible to petition to be removed from the sex offender registry after 10 years of registering. If you're a Tier 2 offender, that's 20 years. And that's the general rule. There are some exceptions. The best thing you can do to inform yourself what those exceptions are would be to hire an attorney who can sit down and discuss the nuances of that statute with you and go through that process with you. It is a bit of a cumbersome process. You do have to serve the law enforcement agency from the arrest, from the district attorney, from the original county of conviction, as well as your local district attorney's office. It's a process that could take roughly 120 days just to get a decision made in the petition. So the best thing you can do if you're interested in this is to call an attorney as soon as possible so that you can start getting the ball rolling on this.
Before you get, though, to contacting an attorney, I think the first step is to understand whether a person's offense falls into Tier 1, Tier 2, or Tier 3. This answer actually is not legally complicated. What a person has to do, number one, is to look up the charge that they have been convicted of. Then they can go to the statute itself, which is Section 290. You can read the statute, or if you're working with an attorney can read it a lot faster and explain it to you. But you basically look in the statute itself and see whether the offense that you have pled to and were convicted of falls under Tier 1, Tier 2, or Tier 3. Most of the misdemeanor crimes that we see are going to be Tier 1 offenses. Those are offenses like indecent exposure, like annoying or molesting a minor. And the word molesting doesn't mean the same thing as a lewd and lascivious conduct with a minor, Section 288, which is commonly known as child molestation. It just means that you are engaging in a conduct motivated by abnormal sexual interest in a child that is annoying or disturbing to an average reasonable individual. But Tier 1 offenses are going to be offenses that are the least serious of the group of sexual crimes, and therefore they carry the shortest period of registration, which is 10 years. After you have registered as a sex offender for 10 years, did not have violations during that period, you can now file a petition, and within a matter of months, you can be finally removed from registration, which is something you would not be able to do. Now, Tier 2 offenses would be offenses that are most likely felonies, but they would be less serious felonies than, for example, rape of a child, child molestation, such as Section 288 offenses. Now, when it comes to Tier 3 offenses, for the most part, Tier 3 offenses are going to be exactly what most of us would imagine. Really serious sexual offenses involving adults or children, forcible rape, child molestation, offenses of that nature. However, there are a couple of surprises, and those are the things that really catch people because, for example, child pornography is one of the offenses that is considered a Tier 3 offense. The definition of child pornography is incredibly broad. A person could be charged and convicted of child pornography for mere possession of any matter that depicts a minor engaging in actual or simulated sexual conduct. Now, most people, when they think about child pornography, they imagine adults, engaged in really disgusting sexual acts with children. They're not thinking about, for example, a youthful-looking female who may be 16 or 17 years of age. They're not thinking about a Romeo and Juliet type of scenario where you may have two young people sending their naked pictures to one another. But unfortunately, depending on the jurisdiction you're in, some of the law enforcement agencies and some of the district attorney offices will pursue very aggressively these child pornography convictions. And so you could end up with people who, although they have made a mistake, as far as their overall culpability, they may not be as egregious of a person or as an offender than, for example, someone who is a Tier 2 offender, but nonetheless, they may have to register for the rest of their life, and that could be really significant for them. And so if a child pornography offense was a felony, that is a lifelong registration for an individual. And as we have discussed, it does not need to necessarily involve very young children. It could be somebody who is a post-pubescent teenager or someone who a person may have been in a relationship with and exchanged some photographs with.
And you bring up the child pornography charge, which I think is which I want to comment on, because that charge itself wobbles, meaning it could be charged as a misdemeanor or it could be charged as a felony.
In the discretion of a prosecutor or a judge.
Exactly,
Dustin.
exactly. And the difference between a misdemeanor or felony is crucial for 290 purposes. If it is convicted as a misdemeanor, then it's a Tier 1 offense, requiring 10-year registration, and then you can request to be removed after those 10 years. If it is a felony, then it's Tier 3, requiring that lifetime registration. And it's not something that you can fix after the fact. Something that we're seeing as this new law is being developed and interpreted by our courts is that expunging a conviction and seeking a reduction from a felony to a misdemeanor does not alter your tier designation. It does not alter your duty to register. So it's very important on the front end of things that you make sure that you're not signing yourself up to a lifetime of registration needlessly, that you're working with your attorney to find a resolution that prevents a lifetime registration before that gets entered as a conviction.
Now, in fairness, Dustin, a lot of this did not matter as much, let's say 10, 15 years ago, because the law was very different. Any offense, such as child pornography, misdemeanor or felony, would have triggered a lifelong registration requirement. So it really did not matter whether a person would have pled to misdemeanor or felony for purposes of registration. That would have been a lifelong requirement. But now that there is this tier designation, I think attorneys need to be very careful and clients need to be very careful in making their decision how they resolve a case, because it doesn't only affect them in a short term, but it also has profound and potentially lifelong consequences when it comes to registering. Now, I want to discuss a related topic of tier designation. I know we have mentioned earlier in this video that obviously contacting an attorney is a really good first step in learning what your tier designation might be. But there are some other steps that a person could take short of hiring a lawyer in doing their preliminary research so they can at least find out, am I eligible for this relief in the future, or am I completely out of luck because of the offense I pled to 10, 20, 30 years ago?
Definitely. I would encourage you to go to your registering law enforcement agency and ask them to obtain a tier designation letter from the California Department of Justice. That would be sent to you, and it would state quite clearly what their understanding of your tier designation is. If there's an error there, that could be corrected and addressed with legal representation. But that would be a very good starting point to determine whether or not you qualify for to petition to terminate the sex offender duty.
And I think that's a very important point that you're bringing up, Dustin, because if a person is a Tier 2 registrant, but they really would like to have their registration terminated in 11 years as opposed to 20 years, there's simply nothing we're going to be able to do to help them unless the requisite period of time passes. On the other hand, if they are eligible and they did not realize that they're eligible sooner than they had thought, then of course they can get started and get the petition filed and hopefully remove that from them.
And actually, I think it is very important that if you want to determine whether or not you could petition to be removed from the registry, that you do contact an attorney, because the statute itself is pretty nuanced.
Pretty convoluted, I would say. I had to reread it multiple times, and I've been doing this for almost 20 years.
There are exceptions to the 20-year rule for certain Tier 2 offenses. So while the general rule is that you have to wait 20 years before you could petition for removal, there are circumstances that would allow you to petition after 10 years.
And the last topic we want to touch on is the related area of record clearance, which sometimes creates confusion in the minds of our clients or prospective clients. Because while normally getting a person's record expunged or dismissed under Section 1203.4 works to remove any penalties or disabilities stemming from a criminal conviction, it unfortunately does not apply in the category of cases we're discussing today, which are registrable sex offenses.
Right, and there are some of those offenses which can't be expunged anyway, and then the ones that can be expunged but still carry 290 consequences, getting those types of convictions expunged does not terminate the duty to register. It's one of the exceptions, unfortunately, of the expungement statute.
And so it's very important to work with an attorney who understands how sex offender registration works and how Section 1203.4 works, because I think a lot of people have just very general familiarity with the expungement statute. They think it's very easy to litigate it, and it can be, because it could be just a form-driven petition if a person completed probation and has not violated anything else. But in those circumstances where a person has to register as a sex offender, it's very, very critical to educate the client that merely getting expungement relief does not remove the person or does not alleviate the burden or duty to register as a sex offender, because then these folks will come to us when they get arrested for failure to register in violation of Section 290, and they could be looking at either a felony or a misdemeanor. To summarize this presentation, if you or a person you care about have been convicted of an offense in California that requires mandatory sex offender registration for life, there may be good news for you. Effective January 1st, 2021, California created 3 different sex offender tier designations. Folks who are designated as either Tier 1 or Tier 2 offenders now have an opportunity to petition for removal from sex offender registry after completing either a period of 10 years or a period of 20 years, depending on whether they fall into Tier 1 or Tier 2. To determine whether you are a Tier 1, Tier 2, or Tier 3 offender, you can contact an experienced attorney who works with clients charged or convicted of sexual offenses, or you can request a tier designation from the agency that you're required to register with. Once you're able to confirm that you fall into either Tier 1 or Tier 2 registration, you can start the process of submitting a petition. That petition has to be served on the agency first. After a 60-day waiting period, you will then have the district attorney's office determine whether or not they have any objections to the petition. If within additional and consecutive 60-day period they have no objections, you will be removed from the registry. If they object, then there will be a hearing in court. You are allowed to present evidence, just like the other side is allowed to present evidence, and questions pertaining to your rehabilitation and the dangerousness that you may or may not continue to pose to the community will be raised at that hearing. If you are not satisfied with the outcome of the hearing, of course, you always have the ability to appeal. It's very important in these matters to always have an experienced criminal defense attorney, because registering as a sex offender is very burdensome. Failure to register carries additional consequences, and if you have truly been rehabilitated, you and your family deserve to be permanently removed from the registry so that you no longer have to suffer all of the stigma, shame, and embarrassment, as well as potential housing, employment, and other forms of discrimination that unfortunately come from a conviction. In summary, many people in general public have a very negative and understandably negative view of sex offenders as a population. But in our practice, we have learned that there are many, many types of sexual offenses which do not always correspond with the person's viciousness, dangerousness, or some sort of sexual pathology. The definition of many crimes that require sex offender registration is extremely broad, and oftentimes people who can be successfully rehabilitated in a fairly short period of time are trapped in the system and get convicted of these crimes that carry these very lengthy registration periods. If you or your loved one have been convicted of an offense and you have been required to register as a sex offender, please make sure to research whether you fall into Tier 1 or Tier 2 registration. And if you do, make sure to contact an experienced criminal defense attorney so you can begin the process to remove yourself. Thank you very much for watching this video. Please click like, subscribe, leave us your comments, and if you have any questions, please get in touch with us. We'd be happy to do a follow-up video or address any other questions you guys might have. Thank you for watching.